Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. Today with our host Jim York and his guest Don Ross, president of Ross Title.
Thank you, Michael, for the introduction. Don, just give us a little background about yourself. I know we've been doing business for years together, and you're one of the prominent attorneys in town with a title company. So just give our viewers a little bit of background about yourself.
I grew up in New England, moved to Florida a number of years ago, practicing attorney here in Collier County for about 30-plus years. Sole shareholder of Ross Title and Escrow, shareholder in the law firm Ross, Lanier and Dyfick, and a shareholder in Downing Fry Realty, Inc. So I've pretty much covered every aspect of the real estate game that you can imagine.
That's right. Where is your office located?
Office is on the corner of 6th Avenue North and 41 in Naples.
Hey, Don, this evening we're going to be talking about contracts. And
okay.
What we want to maybe start off with is, where do we start when we're sitting down with a client to do a contract for purchase?
Well, assuming you've had some sort of initial contact, if it's a buyer, you have to give them some broad overview of the contract, what it means, what their duties are, how much things cost, what are their concerns, what are they worried about, do they have any particular issues that would affect their ability to buy the property or the property itself.
Pre-qualifications.
Pre-qualifications,
right.
Do they have a lender, name, telephone number, have they spoken to the lender, and that should be a good start.
Okay, and then when we step through the contract, we start with the seller's name and the buyer's name. Let's say the next part of the contract would be what's included in the price of the home, such as furnishings. Maybe you could just elaborate a little bit on that part.
Well, I brought a contract with me, and there are about 30-plus contracts in this state, but this is the one that's we use in Naples primarily, the Naples Board of Realtors contract. So I'll get the price, and then I'll go through the personal property that's included in the standard form, which is in the first 5 lines of the contract, and it includes appliances and things of that sort. And there's a place at the beginning of the contract where they can add things if they're buying things above and beyond normal fixtures. If there's furniture, if there's a boat, if there's artwork, things of that sort. And while I'm discussing that, I'll ask the buyer, are you planning on getting a mortgage? Because if you are, putting those things in this contract might cause an issue if you haven't talked to your lender at first.
It does. It definitely does cause an issue.
Oh, absolutely.
So how would we address that with a client?
Well, if they're not getting a mortgage, it's not a problem.
Right, but if they were getting a mortgage and furniture was included in the purchase of the sale, would we do an addendum?
Well, I recommend they do a bill of sale and treat it as though they were buying an automobile. It's tangible personal property. It's separate from the real estate. The lender will have the property appraised as though it were vacant. So you want the property to, the price to reflect, the appraised value. So it's a separate agreement, and it's evidenced by a bill of sale. The bill of sale can be filled out. It can describe the property, which is a whole other art form. And the bill of sale itself, I usually make contingent upon the closing of the real estate. So it doesn't go into effect unless the real estate closes.
Okay. And I know there's been a lot of questions about this, about, we have TVs on that are attached to walls. How would you handle that when you're purchasing a property? When the person says that is not furniture included, but then it is attached to the wall.
This is where an experienced agent is really critical. I mean, the longer you do this, the more of these things you see, the more you know what to look for. So you get very specific. I mean, I advise agents, I advise people off the street, even though the contract appears to cover it, put it down in the contract. There's a provision in the contract, other terms and conditions, which is a blank area where you can handwrite additional things, or add an addendum specifying that the TVs are included, because some are detachable, and there's an argument over that.
That's right.
There's mirrors in bathrooms that are hanging on a hook that it might look like it's affixed to the wall, which would normally be covered, but because it's hanging on a hook, it's not, and people argue over that. I mean, the irony of this is you could have, and I've seen it, you have $1 million transactions, and then they go to World War III over a mirror hanging in a bathroom.
Exactly.
And it might be a mirror that was in the family that has some emotional value to the seller. So an experienced agent will know to go through the house and make sure these mirrors are, affixed to the wall. If they are, you don't have to worry about it. The TVs I would add, if in doubt, because you're dealing with people who aren't realtors, they're not attorneys, and they may not understand this.
That's right.
So to make sure the communication between the parties is clear, even though the contract might be clear, you ask, and you write it down so that there's no surprise to either side.
And you can't assume anything.
Well, it's not just what's legally effective. It's the clear communication between the seller and the buyer, so that, because they're not experts, they haven't read these contracts for the most part, and even if they have, they may not fully understand them. And you want to make sure that they get to closing, it's exactly as they anticipated it, so that they end up happy.
Then the next part of the contract is, if we want to go over that a little bit more, would be just explain to them about if there's a parking space available or a boat slip, or that's part of the contract.
Well, they have a space for parking spaces, garages, cabanas, storage lockers, boat docks, and slips. A lot of confusion about these. They're conveyed in different manner. You could have a parking space as part of a warranty deed. You could have a parking space that's assigned within the condominium. You could have a boat slip that's part of a submerged land lease. So what's assigned is a sublease to the boat slip. So they have fill in the blanks here. And I do get a lot of questions in particular on boat slips, because people from other states think they actually own the bay bottom or the ocean floor beneath the boat slip. And there are cases where they do, but they're rare. Usually it's part of a submerged land lease, and I've actually had with small condominiums, the association had, in one case, actually let the lease expire, and they're $1 million units.
Oh, really?
And they had to go back to the state and get a new lease. I mean, because the small condominiums tend to be self-managed and nobody keeps up on the details. So you need somebody, again, who can check into things like that. And I'm a big fan of overkill and putting things down. And if you have a question on a boat slip, and it always comes up with people from out of state, because it's handled differently in other states, refer them to an attorney who can explain it to them.
Right. And then, okay, the next part in the contract really is the purchase price. And then maybe you can explain the deposits, the next lines that are there.
The deposit is an interesting thing. The standard, the custom is 10% of the purchase price is the deposit. But the function of the deposit is multiple. One, when you look at the remedies clause at the end of the contract, if the buyer decides they don't want to buy the property and they don't have any way to terminate the contract, the only remedy the seller has under the standard contract here in Naples is to make a claim on that deposit. So you want enough of a deposit where the seller will be compensated adequately if the buyer changes their mind, if they get cold feet. And psychologically, the seller wants to see enough of a deposit where they feel comfortable taking their property off the market, that this person is actually serious about purchasing this property. The test I use, as I explain to lay people, you want a deposit big enough where the buyer is going to say, ouch, if they're going to walk away from the transaction. Otherwise, if I were able to go down Gulf Shore Boulevard and put a $500 deposit down on 20 condominiums and have closing in 2 months, I'm going to try to resell those units, and I'll walk away from the other deposits that I wasn't able to resell.
Okay. And then just explain a little bit about what happens is, at the end there, where what is due after the deposits, when it's due.
Oh, well, the deposit, they have a number of different blocks on line 24. You can have, if you don't check any of these blocks, it accompanies the offer.
Right.
Okay. But you can check a block and say it's X days after the effective date, which is the last date the contract is signed or initialed
both parties.
By both parties. The practice of having a deposit X days after the effective date, you have people looking at a home, they don't have their checkbook, they can't get to it, so that's generally why it's used. From a legal perspective, you know, until money is down, they can withdraw. I mean, going back to our remedies clause, if you have a fully signed contract and the deposit is due 3 days after the effective date, and then the buyer finds something else that they like better, or they get cold feet, or the stock market crashes, or Russia goes to war, chances are the buyer is not going to put that deposit down, and you have no remedy against them, because the sole remedy that the seller has is the money actually down.
Okay. And then the next part would be when the offer is submitted and when they have the time to counter or accept the offer, right?
Yes. Well, you go to the second page and they have period of offer, and counter offer, and effective date at the top of page 2. And I have clients who will ask, well, what's a reasonable time to give the seller to accept? And of course the answer is it depends. You know, where is the seller? Are they on a cruise ship? Are they in another state? Are they in a different time zone? Is it an elderly couple who needs to consult with someone? Is it somebody who's not financially sophisticated enough to understand all this and they want their lawyer to look at it? So you take all those factors under consideration and try to give the seller a reasonable time to respond. But if you give the seller too long to respond, you're giving them time to take this offer and call all their friends and say, hey, I have an offer for this, are you interested? So it's a balancing act.
Balancing. And closing date would be?
The first rule, well, time is of the essence for the closing date in this contract, which means if you don't close on exactly that day, with the few exceptions in the contract, you're in breach of the contract and your deposit's at risk. It's, you know, up north, a lot of contracts don't have time is of the essence. In New York, places like that, most of the attorneys I deal with along the eastern seaboard, in Chicago, time is not of the essence, so they're used to transactions where they can get another couple of weeks, or they can argue about the terms of a mortgage or the inventory and delay the closing a week or two. Whatever's reasonable under the facts and circumstances. Under this contract, you don't have any of that. You're closing on that day, period, end of story, with few exceptions. And you want to make sure it's during the week. I mean, when I don't check, it ends up being a Saturday or a Sunday, and you don't look too professional when you pick a Saturday or Sunday.
Okay, Don, we're going to take a little short break, and we'll be back in 1 minute. Thank you.
When picking a realtor, don't just pick anyone. Pick someone with experience. Pick someone with a proven track record. Pick a realtor like Jim York from Downing Fry Realty, the #1 brokerage with the most real estate transactions in the area.
My husband and I had very specific ideas about what we wanted in our new home. Jim York was able to help us find the home that was ideal for us.
With over 20 years of real estate experience in Southwest Florida, Jim York has negotiated over $200 million in sales contracts. Selecting the right realtor is a critical decision that can earn you thousands when selling or save you thousands when buying.
Jim also helped us with a mortgage lender and a good real estate attorney. He went that extra mile, and his experience says it all.
Call Jim York for a no-obligation meeting at 239-273-6727 or visit his website, www.naplesyorkrealestate.com.
Welcome back. Don, let's just go over the contingencies in the contract, and maybe let's just start with mortgage. But Before we go into that, if somebody's making a cash offer, just explain that to our viewers here about they can still get a mortgage also.
They can still get a mortgage. A lot of wealthy buyers will make a cash offer with the idea that it will be more attractive to the seller. It's one less thing the seller has to worry about, whether that buyer will qualify. I've seen situations too where they're actually going to pay cash, and they'll use a short closing with a cash offer to get a better price. I'll close in 2 weeks, and and the property is off the market a shorter time period during season.
But they are still able to go get a mortgage. It does say that in the...
Yeah, absolutely. All this does is protect the buyer's deposit. If they don't get a mortgage, and it's because of the buyer himself or herself, or the condition of the property. It protects the deposit. It doesn't say they can't get a mortgage. They can borrow the money from a private source. They can borrow from a bank. It could be a gift. But it just protects the deposit. That's all it does.
Okay, on the mortgage contingency, how long does normally people have for a mortgage contingency?
Well, the default language is 45 days, and you're supposed to apply for the mortgage within 10 days. And what I tell buyers is, they might be friendly with Wells Fargo. They might have all their funds up in New York at Bank of America. Try to use a Florida branch because they're familiar with the laws in this state, and they're not going to ask for things that might be customary in New York, but are not necessary here because of statutory changes or other differences between Florida and New York, just using New York as an example.
And just explain also, if the appraisal comes in lower than the purchase price, what happens then?
That's a good one. Depends upon the amount of the mortgage in proportion to the sales price. I mean, this is a pretty frequent situation. For example, $500,000 sale, the buyer is only borrowing $250,000. In that case, if the appraisal comes in at $400,000, and you look at the terms of the financing contingency, and it's subject to them borrowing $250,000 at 4% over 30 years fixed, chances are that loan is going to be approved, even at $400,000. So there's no safety, if you want to put it that way, that you're going to be able to get your money back if it doesn't appraise at the purchase price. You're going to look at the size of the mortgage you're getting and whether or not the bank will lend. Let's say you have an 80% mortgage. Now, if the appraisal comes in low, well, the chances are higher that the appraisal will be enough to have a letter of adverse determination from the lender saying, sorry, you're not getting a loan based on this appraisal.
That's right. Okay, the next section in our contract would be go to the inspection period, inspections.
Inspections are really an art. We've got 3 different possibilities. There's the general inspection process, where a buyer has 15 days to get whatever inspections they want. Then they have 5 days after that to make a request of the seller for either a credit or remediation. The seller then has 10 days after that, we call it the seller's response period, to say yes or no. In my case, I get this a lot. They'll give me the buyer's request. Is this reasonable, Don? Are they asking for more than they're entitled to? What do I do? And you spend 10 days working on a draft of a response. And if the response comes back from the seller that, yes, I will fix all these things, you're going to have a closing unless the financing doesn't come through. If the seller says no, and it's saying no as to something that should be in working condition and is not legitimately, then the buyer has 5 days to cancel the contract, get their money back, and walk away. But within those very broad confines is a lot of issues.
Okay, and what else should somebody watch in our contract or be aware of? I know we have another 10 pages that go there, but we don't have 2 hours either. So
That's
could you just touch base on a few other things?
Well, they want to know their costs. The seller, the big costs for the seller generally are they have a commission usually, they have their own attorney usually, they're responsible for documentary stamp tax on the deed, which is $7 per thousand, so a $500,000 transaction is 7 times 500, which is $3,500. The buyer's main cost usually is the title insurance, and that's $5.75 per thousand for an owner's title policy. It doesn't include lender policies. Those are the main costs. Then there's prorations and credits for maintenance, taxes. There might be a special assessment that needs to be addressed. And I usually run through the numbers with them so that they aren't surprised.
Right.
Because it's different from wherever they come from.
That's right, right. And on the closing thing, how about the CDD? How is that handled? If people don't know what a CDD is, maybe you could just touch, I know we're going back there.
We have, it's called a Community Development District. And the developer of a project, for example, may have used bonds to help build the infrastructure, the roads, lay the pipes, the wires, the lights, things of that sort. And it's incorporated within the ad valorem tax bill, and it's paid off over time. And this contract calls for an addendum if there is a CDD or a Community Development District fee, where it's disclosed what the amount due is and whether or not the buyer is assuming it. I mean, I live on Marco Island. I mean, there was a decision to make all the homeowners connect to city sewer. And there was a similar assessment like this made. It was about $18,000. So you want this to be known to the buyer so they can decide whether they're going to assume it or they're going to reduce the price, whatever they're going to do. The other item you referred to was the MSTU, and that's a municipal service or benefit taxing unit. It's an ongoing annual fee. There is no payoff, and the fee is generally used to pay for cutting the grass of the meridians and maintaining the flowers through the gated community so that it looks nice.
Okay. On the other parts of the contract, if somebody wants to get out of a contract, what do they have to do to terminate a contract as a buyer?
Well, that's
giving you a loaded question.
Yeah, I can talk about that one for years. Of course, there's the customary, I'm just not going to close and,
that's right.
and try to take my deposit. The deposit cannot be released under this contract unless the seller and the buyer both sign a document agreeing to the release of the money to whoever, the seller in all probability. And most buyers will look at that and say, why would I want to do that? What's in it for me to sign this release of my $5,000 to the seller? You know, they're usually very upset at that point.
That's
Something
right.
didn't work out the way they anticipated. They might feel that the property was misrepresented to them, or they discovered something terrible. I mean, I've had people discover that there's radon in the unit. Even though it was going to be remediated, there's cancer in the family. They don't care. They don't want to worry about the remediation device breaking down at 3 in the morning. I mean, this actually happens. And they just say, I'm not closing. And then the money sits indefinitely unless either party asks for the money to be given to the court. And there's a legal procedure where you do that. And if it's that sum of money, it's usually not cost effective to go hire a lawyer to fight over $3,000 or $5,000. So after some period of time, they reach some split after the emotions have calmed down. I mean, a lot of it is emotions. It really is.
Right.
You know, managing the people and keeping things in perspective.
Okay. Well, Don, I appreciate you coming, and we have a question here from the audience, and we're going to be right back with our question from the audience. Thank you.
Selecting the right realtor is a critical decision that can earn you thousands when selling.
Jim sold our villa in just 2 days. We got the highest price in the community. He then helped us to negotiate and purchase our new home here in Tiburon. I'd recommend Jim. His expertise made all the difference.
Call Jim York for a no-obligation meeting at 239-273-6727 or visit his website, www.naplesyorkrealestate.com.
Welcome back. Let's go to Michael with our audience question. Thank you.
Don, we have a question from the audience. Linda?
If I'm looking at a home for sale by owner, what would be the procedures I need or protections I should know before I proceed in making an offer?
Tremendous question, Jim. I mean, seriously, what can you do to protect yourself when you're dealing with the seller on your own? What safeguards do you have? You have zero safeguards. You really do. I mean, most people, they do a handful of closings in their entire life. And you're trusting the integrity plus the expertise of the seller. I mean, they could be the nicest people on the planet Earth, but they're not real estate attorneys, they're not realtors, and they don't know what's necessary to transfer that property, whether the property is worth what's being offered, what a fixture is, for that matter, referring back to an earlier point.
Or inspections.
Inspections, reading a document like this and trying to fill in the blanks on your own without an experienced realtor or an attorney explaining it is a nightmare. To get effective communication between the parties, you need a good realtor, and a good realtor has a team of an attorney or a title company. They have inspectors, they have people who do remediation, they have mold sanitizing companies. They've got a whole net, accountants, estate planners that they all work with on a consistent basis. And plus, they're familiar with this area. And you get people coming from other countries. They don't know how to take title. That's right. They have no idea what's the customary practices in this community. They don't know the reputation of the community. They have no idea what the case law is. So to protect yourself, I would check around and try to find an experienced agent or attorney, somebody who's been involved in actual closings in that community, somebody who's been around for a number of years.
Somebody like you.
Well, obviously. But, I mean, really, you want people with experience.
Exactly.
I mean, you can be taught whatever you want in school, but there's no substitute for experience. I mean, there really isn't. I mean, you've seen it all. You know what to look for. We were talking about the mirrors early. I mean, an experienced realtor who had been in a situation like that before would know to move the mirror in the bathroom or ask about the TV on the wall. Some person coming down from Canada, no idea. They'd have no idea. And they don't know whether it's even worth what the seller wants. Most sellers, they get psychologically, they want to get back what they put into it. This is what I have in it. They haven't quite accepted fully the fact that we've had a recession and it might not be worth that anymore. So get somebody with experience.
Right. Well, Don, I appreciate you coming this evening, and we'll continue to do business together for a long time, and we'll thank you for coming.
Oh, thank you, Jim. Appreciate it.